Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Hey, just me today. I'm about to take you through the concurring decision of Justice Brown in Obiter and Heller. If you want to hear the majority decision, which was delivered by Justices Abella and Justice Rowe, head on over to the previous episode. Hope you enjoy. The following are the reasons delivered by Justice Brown, concurring reasons. Part 1, Introduction. While I agree with my colleagues, Justices Abella and Rowe, that the mandatory arbitration requirement is invalid, I would not rely upon the doctrine of unconscionability to reach this conclusion. Contractual stipulations that foreclose access to legally determined dispute resolution, that is, to dispute resolution according to law, are unenforceable not because they are unconscionable, but because they undermine the rule of law by denying access to justice and are therefore contrary to public policy. The arbitration agreement between Obiter and Mr. Heller does just that. It effectively bars Mr. Heller from advancing any claim against Obiter, no matter how significant or meritorious. In effect, it is not an agreement to arbitrate, but rather not to arbitrate. In these exceptional circumstances, a central premise of curial respect for arbitration agreements, that they furnish an accessible method of achieving dispute resolution according to law, falls away. On this narrow basis, I would find that the arbitration agreement is unenforceable and would dismiss the appeal and affirm the judgment of the Court of Appeal. Part 2, Analysis. The appeal was framed by the parties in terms of unconscionability, which presents an unfortunate difficulty, since applying unconscionability here amounts to forcing a square peg into a round hole. My colleagues, Justices Abella and Rowe, seek to avoid this difficulty by vastly expanding the scope of the doctrine's application and removing any meaningful constraint. As I will explain, their approach is, in my respectful view, both unnecessary and undesirable. Unnecessary because the law already contains settled legal principles outside the doctrine of unconscionability which operate to prevent contracting parties from insulating their disputes from independent adjudication. And undesirable because it would drastically expand the doctrine's reach without providing any meaningful guidance as to its application. Charting such a course will serve only to compound the uncertainty that already plagues the doctrine, and to introduce uncertainty to the enforcement of contracts generally. Part A, Access to Justice and the Rule of Law. I agree with my colleagues Justices Abella and Rowe that the Arbitration Act applies to this appeal. While the parties' relationship determines what statute applies, the nature of the parties' relationship is the very question to be decided in Mr. Heller's action. Is Mr. Heller an employee of Obiter? Without subjecting that question to a full trial, the preliminary issue of the statute to apply should be determined by reference to the pleadings. The Arbitration Act generally mandates a stay of proceedings when a court action relates to a matter governed by an arbitration agreement. Of the few exceptions to this general rule, this appeal requires consideration only of whether Mr. Heller's action should proceed because the arbitration agreement is invalid. Answering that question is really this simple. As a matter of public policy, courts will not enforce contractual terms that, expressly or by their effect, deny access to independent dispute resolution according to law. This obviates any need to resort to and distort the doctrine of unconscionability. While the parties did not argue this appeal on the basis of public policy, we are of course not bound by the framing of their legal arguments. The central question to be answered in this appeal is not whether Obiter's arbitration agreement is unconscionable, but whether it is invalid, as contemplated by the Arbitration Act. Whether that question is viewed through the lens of unconscionability or public policy, the basis for reaching a conclusion on enforceability is substantially the same. The issues raised by the parties remain the focus. Further, this court has said that courts may consider issues of public policy on their own motion, and for a good reason that, by happy coincidence, touches on the very basis for my objection to the punitive arbitration agreement in this case. Public policy and respect for the rule of law go hand in hand. My colleague Justice Cote stresses freedom of contract, for which I readily share her enthusiasm. Freedom of contract is of central importance to the Canadian commercial and legal system, and, to promote the certainty and stability of contractual relations, often trumps other societal values. Indeed, a hallmark of a free society is the freedom of individuals to arrange their affairs without fear of overreaching interference by the state, including the courts. But while privileging freedom of contract, the common law has never treated it as an absolute. Quite simply, there are certain promises to which contracting parties cannot bind themselves. As this court stated in the estate of Charles Miller, deceased in 1937, quote, "There are cases in which rules of law cannot have their normal operation because the law itself recognizes some paramount consideration of public policy which overrides the interest and what otherwise would be the rights and powers of the individual. It is, in our opinion, important not to forget that it is in this way, in derogation of the rights and powers of private persons, as they would otherwise be ascertained by principles of law, that the principle of public policy operates." End quote. This public policy doctrine has been described by this court as fundamental to Canadian contract law, and its role in the enforcement of contracts has never been doubted. Of course, and as Justice Cote cautions, public policy must not be used as a tool to prioritize idiosyncratic judicial views over the interests of contracting parties. But that is not a live concern under our law. Courts have cautioned against the recognition of new heads of public policy, and the existing public policy grounds for setting aside specific types of contractual provisions are narrow and well established. This court has relied on public policy sparingly, and most recently to limit the operation of forum selection clauses and exclusion clauses, which raise concerns relating to administration of justice, and to limit the operation of restrictive covenants. While the considerations relevant to each type of clause vary, public policy furnishes the common and narrowly framed solution. And by focusing on the specific rationale that suggests a certain type of clause is unenforceable, this court has sought to ensure a disciplined approach by providing concrete guidance and developing specific principles that apply to similar provisions. The ground upon which I proceed is that which precludes an ouster of court jurisdiction, or, more broadly, which protects the integrity of the justice system. As Lord Atkins stated in Fender and St. John's Mildmay, ousting the jurisdiction of the courts is harmful in itself and injurious to the public interest. A provision that penalizes or prohibits one party from enforcing the terms of their agreement directly undermines the administration of justice. There is nothing novel about the proposition that contracting parties, as a matter of public policy, cannot oust the court's supervisory jurisdiction to resolve contractual disputes. Indeed, irrespective of the value placed on freedom of contract, courts have consistently held that a contracting party's right to legal recourse is a right inalienable even by the concurrent will of the parties. This head of public policy serves to uphold the rule of law, which, at a minimum, guarantees Canadian citizens and residents, quote, "a stable, predictable, and ordered society in which to conduct their affairs," end quote. Such a guarantee is meaningless without access to an independent judiciary that can vindicate legal rights. The rule of law, accordingly, requires that citizens have access to a venue where they can hold one another to account. Indeed, quote, "there cannot be a rule of law without access. Otherwise, the rule of law is replaced by a rule of men and women who decide who shall and who shall not have access to justice," end quote. Unless private parties can enforce their legal rights and publicly adjudicate their disputes, quote, "the rule of law is threatened and the development of the common law undermined," end quote. Access to civil justice is paramount to the public legitimacy of the law and the legitimacy of the judiciary as the institution of the state that expounds and applies the law. Access to civil justice is a precondition not only to a functioning democracy, but also to a vibrant economy. In part because access to justice allows contracting parties to enforce their agreements. A contract that denies one party the right to enforce its terms undermines both the rule of law and commercial certainty. That such an agreement is contrary to public policy is not a manifestation of judicial idiosyncrasies, but rather an instance of the self-evident proposition that there is no value in a contract that cannot be enforced. Thus, the harm to the public that would result from holding contracting parties to such a bargain that they cannot enforce is substantially incontestable. It really is this simple. Unless everyone has reasonable access to the law and its processes when necessary to vindicate legal rights, we will live in a society where the strong and well-resourced will always prevail over the weak. Or, as Frederick Wilmot Smith puts it, quote, legal structures that make enforcement of the law practically impossible will leave weaker members of society open to exploitation at the hands of, for example, unscrupulous employers or spouses, end quote. The reference to making enforcement of the law practically impossible leads to a further related point. There is no good reason to distinguish between a clause that expressly blocks access to a legally determined resolution and one that has the ultimate effect of doing so. That this is so is illustrated by the judgment of Justice Drummond in Nova Mese Limited and Cut Price Deli Limited. In Nova Mese, the terms of a franchise agreement permitted the franchisor to take control of the franchisee's business if either party threatened to commence, or commenced, legal proceedings against the other. This clause, Justice Drummond explained, was, quote, capable of operating as a powerful disincentive to the franchisee to take proceedings of any kind against the franchisor, no matter how strong a case the franchisee may have had that it has suffered a wrong, end quote. Summarizing the relevant principle, Justice Drummond continued, quote, the citizen is entitled to have recourse to the court for an adjudication on his legal rights. A contractual agreement to deny a person that inalienable right contravenes this public policy and is void. A disincentive to a person to exercise its right of recourse to the court can, depending on how powerfully it operates to discourage litigation, amount to a denial of this right just as complete as an express contractual prohibition against litigation, end quote. I agree. At some point, there is no material difference between a provision that discourages dispute resolution and one that precludes dispute resolution altogether. As the Court of Appeal of Alberta recently recognized, quote, insurmountable preconditions effectively amount to a total barrier of court access, end quote. During the hearing of this appeal, Uber's counsel would not concede that a clause requiring an upfront payment of $10 billion to commence a civil claim would necessarily be equivalent to a brick wall standing in the way of dispute resolution. With respect, the conclusion that independent adjudication would be blocked by such a clause is obvious. Courts have long recognized that upfront payments may effectively drive litigants from the judgment seat in the context of requiring security for costs, for example. None of this is to say that public policy requires access to a court of law in all circumstances. As this court has recognized, new models of adjudication can be fair and just. But public policy does require access to justice, and access to justice is not merely access to a resolution. After all, many resolutions are unjust. Where a party seeks a rights-based resolution to a dispute, such resolution is just only when it is determined according to law, as discerned and applied by an independent arbiter. The law's historical view was that arbitration could not yield dispute resolution according to law. Any arbitration agreement that removed contractual disputes from the purview of the courts was unenforceable as a matter of public policy. Courts, in essence, took the view that an agreement to arbitrate had the effect of precluding any legitimate form of dispute resolution. Contracting parties were seen as being unable to access justice without access to the ordinary courts. Given this hostile judicial posture, legislators intervened by enacting modern arbitration legislation, prompting courts to accord due respect to the use of arbitration as a dispute resolution mechanism, particularly in a commercial setting. Our conception of access to justice has been modified accordingly to account for the other important objectives pursued by the Arbitration Act. It is now accepted that courts are not the only bodies capable of providing dispute resolution according to law. Indeed, arbitration is endorsed and encouraged as a means for resolving disputes. Uber's position requires this court to accept that the change in judicial posture following the enactment of modern arbitration legislation leaves no room for the operation of public policy. But curial respect for arbitration and for parties' choices to refer disputes to arbitration is premised upon two considerations. First, the purpose of arbitration is to ensure that contracting parties have access to a good and accessible method of seeking resolution for many kinds of disputes that can be more expedient and less costly than going to court. Second, courts have accepted arbitration as an acceptable alternative to civil litigation because it can provide a resolution according to law. In other words, any means of dispute resolution that serves as a final resort for contracting parties must be just. This is important because, unlike the submission of existing disputes to arbitration, and contrary to my colleague Justice Cote's assertion, an agreement to submit all future unknown disputes to arbitration is not simply a substitute for the parties' negotiations. Rather, it serves as a transfer of dispute resolution authority away from public adjudicators. The legitimacy of such a transfer rests upon whether it can provide a comparable measure of justice. As this court stated in Sport Masca, arbitration does provide a comparable measure of justice, which is ensured by modern arbitration legislation. Ontario's Arbitration Act serves as an example. Like the Code of Civil Procedure addressed in Sport Masca, the Arbitration Act also contemplates a legally determined outcome. It states that an arbitral tribunal shall resolve disputes according to rules of law and equity, and while contracting parties may be able to opt out of this section's application, they are at least entitled to the inalienable benefit of fair and equal treatment. The Arbitration Act also contemplates court oversight throughout the arbitral process. Where a clause expressly provides for arbitration, while simultaneously having the effect of precluding it, however, these considerations which promote curial respect for arbitration dissolve. And here is where the public policy principle preventing an ouster of court jurisdiction continues to operate. The legislature could not have intended that by enacting the Arbitration Act, arbitration clauses whose effect precludes access to justice would be untouchable. Yet, Uber's position, and I say with respect, my colleague Justice Cote's position, require imputing that very intention, an intention that would defeat the legislature's purpose in enacting the Arbitration Act of promoting access to justice. Meaning, a measure intended to enhance access to justice is now being used as a tool for cutting off access to justice. That cannot be right. Moreover, access to justice is constitutionally protected through Section 96 of the Constitution Act 1867, which limits the legislature's ability to place restrictions on dispute resolution. As this court stated in Trial Lawyers, quote, "The historic task of the superior courts is to resolve disputes between individuals and decide questions of private and public law. Measures that prevent people from coming to the courts to have these issues resolved are at odds with basic judicial function. The resolution of these disputes and resulting determination of issues of private and public law, viewed in the institutional context of the Canadian justice system, are central to what the superior courts do. Indeed, it is their very book of business. To prevent this business being done strikes at the core of the jurisdiction of the superior courts protected by Section 96 of the Constitution Act." End quote. As I have explained, arbitration does not strike at the core of superior court jurisdiction because arbitration provides a comparable measure of justice to the superior courts. Preconditions that prevent contracting parties from even commencing arbitration, however, have the same effect as hearing fees that cause undue hardship and deter litigants from advancing legitimate claims in the courts. It follows that, in the inconceivable event that cutting off access to justice was the legislature's intent in enacting the Arbitration Act, that act must not be interpreted so broadly as to sanction agreements that impose such preconditions. In this regard, and again, with respect, my colleague Justice Cote's assertion that applying the principles articulated by this court in Trial Lawyers poses a risk of permanently restraining legislative competence is not well taken. Reports of the death of legislative competence in this area are, like those of the death of freedom of contract, greatly exaggerated. In sum, applying public policy to determine whether an arbitration agreement prohibits access to justice is neither stating a new common law rule, as my colleague Justice Cote characterizes it, nor an expansion of the grounds for judicial intervention in arbitration proceedings. Common law courts have long recognized the right to resolve disputes according to law. The law has simply evolved to embrace arbitration as a means of achieving that resolution. Contractual stipulations that prohibit such resolution altogether, whether by express prohibition or simply by effect, continue to be unenforceable as a matter of public policy. Subpart 1. The rule of law's impact on the competence principle. Before commenting on the types of clauses that by their terms or effect foreclose access to legally determined dispute resolution, I pause to comment on the competence principle. There are two aspects to this principle. First, arbitrators are empowered to rule on issues relating to their own jurisdiction. Second, arbitrators generally should make such rulings before they are decided by the court. The former aspect is implemented expressly in legislation like the Arbitration Act, which states that an arbitral tribunal may rule on its own jurisdiction. This court accepted the latter aspect in Dell Computer Corporation and Union des Commuteurs by defining, quote, a general rule that in any case involving an arbitration clause, a challenge to the arbitrator's jurisdiction must be resolved first by the arbitrator, end quote. An exception applies where the challenge is based solely on a question of law or requires only a superficial review of the record. But even then, the court must be sure that the jurisdictional challenge is not a delaying tactic and will not unduly impair the conduct of the arbitration proceeding. The court's conclusion in Dell was based on the provisions of the Quebec Civil Code of Procedure. As Justice Deschamps recognized, Article 940.1 CCP, which generally directed the court to refer court proceedings in favor of arbitration, quote, incorporated the essence of Article 2.3 of the New York Convention and of its counterpart in the Model Law Article 8, while Article 943 CCP, quote, conferred on arbitrators the competence to rule in their own jurisdiction, end quote. Thus, the CCP clearly indicated acceptance of the competence principle incorporated into Article 16 of the Model Law. This court reached the same conclusion about British Columbia's arbitration regime based on comparable provisions. Like the legislative schemes in Quebec and British Columbia, Ontario's Arbitration Act adopts the same two features that led to the court's conclusion in Dell. Courts are generally directed to stay proceedings in favor of arbitration, and arbitrators are given the competence to rule in their own jurisdiction. It follows that, on this court's jurisprudence, the competence principle also applies to Ontario's legislative scheme. Further, this court has repeatedly recognized, most recently in Wellman, that courts should generally take a hands-off approach to arbitration. The competence principle described in Dell accords with that directive. I agree with my colleagues Justices Abella and Rowe that Dell did not contemplate clauses that effectively prevent access to arbitration. I would therefore recognize a further, narrow exception to the general rule that a challenge to an arbitrator's jurisdiction should first be resolved by the arbitrator. As I have explained, contracting parties cannot preclude access to legally determined dispute resolution. While arbitrators should typically rule on their own jurisdiction, an arbitrator cannot reasonably be tasked with determining whether an arbitration agreement, by its terms or effects, bars access to that very arbitrator. It therefore falls to courts to do so. Nothing in the Arbitration Act suggests any other conclusion. Further, and if there were any doubt, the imperative of ensuring access to justice should inform interpretation of the Arbitration Act and its adoption of the competence principle. As this court held in Trial Lawyers, access to justice carries such importance that it maintains a constitutional dimension, which restricts even the legislature's ability to prevent private parties from resolving their disputes. While the question of whether an arbitration agreement bars access to dispute resolution is one of mixed fact and law and may require more than a superficial review of the record, this limited exception to the general rule of referral stated in Dell is necessary to preserve the public legitimacy of the law in general and arbitration in particular. Unlike my colleagues, I would limit this exception to cases where arbitration is arguably inaccessible. It should not apply merely because the parties' agreement contains a foreign choice of law provision. Further, and as with any other challenge to an arbitrator's jurisdiction, courts must be satisfied that the challenge is not a delaying tactic and that it will not unduly impair the conduct of the arbitration proceeding. In addition to creating an exception to the framework set out in Dell, my colleagues direct a new, contested hearing to consider whether there is a bona fide challenge to arbitral jurisdiction that only a court can resolve. In other words, my colleagues say that this hearing is necessary because a court must resolve whether there is an issue of validity that a court must resolve. I say respectfully that this new procedural mechanism is unnecessary and will serve only to complicate and delay proceedings. Indeed, my colleagues appear to recognize this by their warnings that, quote, this assessment must not devolve into a mini-trial, that a single affiant will suffice, and that both counsel and judges are responsible for ensuring the hearing remains narrowly focused. First, it seems to me that any development in contract law that requires a new affidavit from anyone on anything is probably a mistake. More fundamentally, however, and again with respect, my colleagues' warnings seem to me entirely unrealistic. This court might as well tell the parties and the motion judge to keep the hearing to 20 minutes, to conduct it on Zoom during the morning break, or to dispense with cross-examination on affidavits. My colleagues' exhortations, well-intentioned as they undoubtedly are simply futile. Even worse, they will be seen as such. In the face of the realities of litigating the individual motion, it will not matter to anyone what we who dwell on Mount Olympus think about such matters. The motion that my colleagues direct will proceed in the form in which the parties see fit, and the hearing will be conducted in the manner that the parties and the motion judge think appropriate in the circumstances. It therefore seems reasonable to expect that time savings, if any, will be minimal for those cases in which no genuine issue exists for the court to decide. And where a genuine issue does exist, the additional hearing will simply create duplication. Subpart 2. When does a contractual provision effectively prohibit dispute resolution? In evaluating a clause that limits access to legally determined dispute resolution, the court's task is to decide whether the limitation is reasonable as between the parties or instead causes undue hardship. Again, it is helpful to refer to the limitation that the rule of law places on the government's ability to impose hearing fees. I pause here to affirm that courts must show due respect for arbitration agreements and arbitration more broadly, particularly in the commercial setting. It will be the rare arbitration agreement that imposes undue hardship and acts as an effective bar to adjudication. Arbitration may require upfront costs, sometimes significant costs, and far greater than those required to commence a court action. But those costs may be warranted in light of the parties' relationship and the timely resolution that arbitration can provide. Public policy should not be used as a device to set aside arbitration agreements that are proportionate in the context of the parties' relationship, but that one party simply regrets in hindsight. Several factors should be considered to decide whether a contractual limitation on legally determined dispute resolution imposes undue hardship and is therefore contrary to public policy. The first consideration is the nature of disputes that are likely to arise under the parties' agreement. Where the cost to pursue a claim is disproportionate to the quantum of likely disputes arising from an agreement, this suggests the possibility of undue hardship. This consideration must, however, be situated in the context of the agreement as a whole. A clause that discourages the pursuit of certain low-value claims may be proportionate in light of overall risk allocation between the parties. The record here shows that Mr. Heller receives $20,800 to $31,200 per year while working 40 to 50 hours per week for Uber. One would reasonably anticipate that a claim by Mr. Heller would not exceed his total annual compensation. Indeed, Mr. Heller's evidence is that a typical claim against Uber would be for non-payment of fees less than $100. The upfront cost of $14,500 US to advance a claim represents a significant portion of the total compensation Mr. Heller receives each year under his agreement with Uber, and is grossly disproportionate in light of the sort of dispute that the agreement is reasonably likely to generate. It is not the case, as my colleague Justice Cote suggests, Mr. Heller and Uber are simply being discouraged from advancing low-value claims. The costs of proceeding to arbitration are so prohibitive that the agreement effectively bars any claim that Mr. Heller might have against Uber. My colleague describes these costs as comparable to an award of litigation costs, but in my respectful view, that is simply not so. These costs are payable by Mr. Heller in advance and irrespective of the merit of his claim against Uber, and therefore bear no resemblance to litigation costs awarded at the end of proceedings. Thus, much like the clause addressed in Nova Mese, the arbitration agreement here is capable of operating as a powerful disincentive to take proceedings of any kind. The costs payable by Mr. Heller act as an insurmountable precondition that prevent him from commencing a claim. I disagree with my colleague that reaching this conclusion requires further evidence. The record in support is ample. Mr. Heller is required to pay $14,500 to pursue a claim against Uber. That includes a claim for breach of contract, though Mr. Heller's agreement with Uber would rarely, if ever, be expected to produce a claim of that magnitude. These facts are unchallenged. While Mr. Heller may be able to pursue a class action by combining his claim with other individuals in a similar position, that is of no moment here. Class actions are a procedural mechanism, and their use neither modifies nor creates substantive rights. What matters is Mr. Heller's contractual relationship with Uber. Nor, with respect, is the availability of third-party funding a relevant consideration. A litigant does not need to canvass options for third-party financing, likely compromising the quantum of their claim in the process, to benefit from the principle that contracting parties cannot preclude access to dispute resolution according to law. Courts should also consider the relative bargaining positions of the parties. To be clear, an imbalance in bargaining power is not required to find that a provision bars access to dispute resolution. An outright prohibition on dispute resolution would undermine the rule of law, even in the context of an agreement between sophisticated parties. That said, the hardship occasioned by a limit on legally determined dispute resolution is less likely to be undue if it is the product of negotiations between parties of equal bargaining strength. What is reasonable between the parties must be considered in light of the parties' relationship. The role that bargaining strength plays in this context is comparable to the role of the enforcement of other contractual provisions that raise public policy concerns, including restrictive covenants and forum selection clauses. Here, which it does not dispute, Uber maintains a vastly superior bargaining position in relation to Mr. Heller. The agreement between the parties was formed through a contract of adhesion, which Mr. Heller had no opportunity to negotiate. Finally, it may be relevant to consider whether the parties have attempted to tailor the limit on dispute resolution. Arbitration agreements may, for example, be tailored to exclude certain claims or to require the party with a stronger bargaining position to pay a higher portion of the upfront costs. No such nuance is evident, however, in the agreement between Mr. Heller and Uber. It covers any dispute he had with Uber, regardless of its quantum, and requires him to pay all upfront costs required to advance a claim. The ICC rules that apply to the arbitration agreement also appear to be specifically designed for large commercial claims. For example, the rules contemplate an expedited process, which applies only to claims valued at less than $2 million. Far from being tailored to the circumstances, Uber's chosen arbitration procedure tends to affirm that this limitation on dispute resolution is disproportionate. In short, the arbitration agreement between Uber and Mr. Heller is disproportionate in the context of the parties' relationship. Mr. Heller and only Mr. Heller would experience undue hardship in attempting to advance a claim against Uber, regardless of the claim's legal merit. This form of limitation on legally determined dispute resolution undermines the rule of law and is therefore contrary to public policy. It follows that I agree with the Court of Appeal that the arbitration agreement between Uber and Mr. Heller is invalid. In response to my colleague, Justice Cote's critique of this approach, I say that the foregoing represents a straightforward application of the applicable law as stated by this court. By agreeing to arbitrate, contracting parties transfer jurisdiction to resolve disputes from the courts. The point, to be clear, is not whether curial jurisdiction is ousted. It clearly is. The issue is whether such ousting is legally acceptable. In the view of this court, which I endorse and apply here, is that it is acceptable when it is replaced by a mechanism, like arbitration, that provides a comparable measure of justice. The proposition I advance is therefore modest, and viewed in the light of our jurisprudence, uncontroversial. Contracting parties must have access to some means of resolving their disputes according to law. Otherwise, justice cannot be done. While the rule of law is perfectly compatible with agreements to arbitrate, it is incompatible with what is in effect an agreement not to arbitrate, or to preclude parties from resorting to any form of dispute resolution according to law. It is the rule of law, not the rule of Obiter. This is the narrow but fundamental point that divides my colleague Justice Cote and me. I agree that the Arbitration Act is a strong statement of public policy which favors enforcing arbitration agreements. Indeed, and as I have explained, contracting parties will generally be held to their commitment to arbitrate, even when arbitration requires significant upfront costs. But the agreement my colleague seeks to uphold is a non-arbitration agreement. None of the Arbitration Act's objectives require blindly enforcing an agreement labeled as arbitration when its effect, in the context of the parties' relationship, is to ultimately bar access to legal dispute resolution. Indeed, and as I consider below, my colleague appears to recognize as much by granting a conditional stay requiring Obiter to pay for the upfront costs of arbitration. Subpart 3. The appropriate remedy. My colleague Justice Cote says that, even if the agreement here violates public policy, the appropriate remedy is to apply blue pencil severance and strike the selection of the ICC rules. In light of this, and while the parties did not canvass the applicable test, I turn to consider this court's approach to severance. Blue pencil severance is permissible only when it is possible to draw a line through a legal portion of the parties' agreement, leaving portions that are not tainted by illegality without affecting the meaning of the part remaining. It is therefore important to note here what my colleague Justice Cote views as separate terms in the agreement between Obiter and Mr. Heller are in fact drafted as a single provision. As I have explained, the illegal portion of the parties' agreement is the cumulative effect of this provision. Obiter and Mr. Heller agreed to submit all future disputes to mediation, which requires a significant upfront cost, following which any unresolved claim would be submitted to arbitration, requiring additional upfront costs. Reducing the cost of dispute resolution could be achieved by selecting between or combining several options. The commitment to mediate could be struck, references to the ICC rules could be struck, and the commitment to arbitrate could be struck. Blue pencil severance is achieved by mechanically removing illegal provisions from the contract. Here, there is not a single component of the arbitration clause that is, on its own, illegal, and that could be struck with a blue line, as my colleague Justice Cote suggests. Moreover, the purpose of severance is to give effect to the intention of the parties when they entered into the contract, and any application of the doctrine should be restrained. As my colleague correctly observes, the agreement here may very well embody not just the intention to arbitrate, but also the intention to prohibit either party from advancing claims valued at less than $14,500 US. Barring such claims, however, in the context of this agreement between these parties, is precisely what makes the arbitration clause illegal. It is therefore impermissible to strike any legal portion of the agreement without fundamentally altering the consideration associated with the bargain and doing violence to the intention of the parties. I also say that the remedy my colleague Justice Cote would ultimately award, granting Obiter a conditional stay of proceedings, is inappropriate here for two reasons. First, it is difficult to conclude from the cases cited by my colleague Justice Cote that such a remedy is even available in this context. In Popak and Lipsick, the court directed a proposed arbitrator to set a timetable or advise that it would not take jurisdiction, so that a court could otherwise determine whether the arbitration agreement was unable to be performed. In Fuller Austin Insulation Incorporated and Wellington Insurance Company, the court was not dealing with a stay in favor of arbitration proceedings, but rather a stay of court proceedings pending a related arbitration proceeding. The jurisdiction to stay proceedings did not arise from arbitration legislation and was therefore referred to by the Saskatchewan Court of Appeal as an extraordinary indulgence. And in both Iberfleet SA and Ocean Star Container Line and Continental Resources Incorporated, an East Asiatic company, the proposed court action was stayed on the condition that the defendant waive any time-related defenses in the relevant arbitration proceedings. One might question whether it was appropriate to impose such a condition rather than leaving the availability of any applicable defenses to the arbitrator's discretion. In any event, however, and even on a broad reading, the conditions imposed in Iberfleet and Continental Resources simply facilitated the intention of the parties' agreements to proceed with arbitration in a timely manner rather than delaying in the courts. Which brings me to my second point, being that to award a conditional stay is simply to grant notional severance by a different name. There is no bright line of illegality here, and the doctrine of notional severance is therefore inappropriate. My colleague Justice Cote would, however, effectively superimpose such a bright line onto the parties' agreement by reading in a requirement that Uber advance the fees of the arbitration. Her view, as I understand it, is that because Mr. Heller has given sworn evidence that he cannot afford the fees required to pursue his claim, Uber must advance those fees. Taking this reasoning to its logical conclusion, Uber would be required to advance the arbitration fees for any driver in a comparable financial situation who intends to commence a claim against Uber. While such a claim may be devoid of any merit, Uber is encouraged to take solace in the possibility of recovering its costs, notwithstanding that any award of costs would be made against a driver who has already demonstrated an inability to pay. It goes without saying that neither party could have intended such a result. Unlike the conditions imposed in Iberfleet and Continental Resources, the condition my colleague would impose completely rewrites the parties' agreement in an attempt to render it enforceable. The pathway to reconciling this outcome with my colleague's stress upon party autonomy and freedom of contract is elusive. The only available remedy in response to the illegality I have identified is to find that the entire arbitration agreement is unenforceable. Any other remedy would require considerable distortion of the intention of the parties. Part B. The doctrine of unconscionability. While the foregoing is sufficient to dispose of the appeal, I offer some observations on the reliance placed by Justices Abella and Rowe on the doctrine of unconscionability. In my respectful view, the doctrine of unconscionability is ill-suited here. Further, their approach is likely to introduce added uncertainty in the enforcement of contracts where predictability is paramount. In Norberg and Weinrib, Justice Sapinka commented that the doctrine of unconscionability and the related principle of inequality of bargaining power are evolving and, as yet, not completely settled areas of the law of contract. More than 20 years later, this uncertainty persists, even at the most fundamental level of determining the rationale that underpins the doctrine's existence. Rather than unsettling the doctrine further by jamming it with what are in substance public policy concerns, the preferable course, in my view, would be to develop unconscionability in a manner that places more emphasis on reasoning than results, to ensure that the doctrine is conceptually sound and explicit in its policy underpinnings. Subpart 1. Confusion in terminology. At least some of the uncertainties surrounding unconscionability can be attributed to varying usage of the term unconscionable. Unconscionability as an independent doctrine is a specific concept, like duress and undue influence, that provides a basis upon which a transfer may be reversed. But unconscionability may also refer, in a more general sense, to a unifying theme or organizing equitable principle, or to a constituent element of a distinct legal test. Some commentators suggest that unconscionability as a broader principle explains several independent rules in contract law, including those relating to forfeitures, penalties, exclusion clauses, duress, and restraint of trade. While it may be that unconscionable is an apt description for multiple and various circumstances, it is important to distinguish unconscionability as an independent basis for setting aside transactions. For example, even though in a generic or lay sense, the arbitration agreement at issue in this appeal might well be considered unconscionable, it does not follow that it is unconscionable in the specific sense contemplated by the equitable doctrine of that name. As this court said in Ryan, unconscionability has developed a special meaning in relation to inequality of bargaining power, and use of the term in other contexts therefore has the potential to cause confusion. To avoid such confusion, the term unconscionability should be used to refer only to the independent doctrine of that name. Specificity is critical here, because the same policy rationale does not underlie each of the distinct concepts that unconscionability may be said to explain. Rules relating to substantive concerns with specific contractual provisions, such as penalty and exclusion clauses, arise independently from and address different concerns than rules that address procedural concerns surrounding contract formation. It is therefore important to elaborate on the criteria that form the basis for reaching the conclusion that a contract or contractual provision should be set aside. Attempting to jam multiple grounds for setting aside contracts and contractual terms into one single principle serves only to obfuscate those criteria. To move forward in a coherent and rational way, it is absolutely imperative in connection with the doctrine of unconscionability to resist appeals to unreasoned intention. Courts must not develop contract doctrines that invite ad hoc judicial moralism or palm tree justice. But unreasoned intuition and ad hoc judicial moralism are precisely what will rule the day, in my respectful view, under the analysis of my colleagues Justice Abella and Rowe. In their view, judges applying unconscionability are to mete out justice as they deem fair and appropriate, thereby returning unconscionability to a time when equity was measured by the length of the chancellor's foot. As Professor Bigwood writes, quote, "Acceptance of such freewheeling approach is also acceptance of the risk that those subject to Canadian law in this area will lose the very virtues of guidance, transparency, and accountability that come with forced specificity in application, justification, and analysis. To the extent the test bypasses such natural controlling phenomena of the common law method, it certainly risks decline into unprincipled and undisciplined judicial decision-making, and thus could rightly be viewed as an enemy of reason, discipline, and the rule of law." End quote. Subpart 2. Unconscionability as an independent doctrine. Focusing squarely on the doctrine of unconscionability reveals that it does not apply to this appeal. At the outset, I emphasize that unconscionability applies to all types of contracts, indicating by implication that its application must be highly exceptional. Unconscionability is also relevant to unjust enrichment, providing a means by which an apparent juristic reason, example, donative intent or contract, may be negated. Broad ramifications thereby flow from how the doctrine of unconscionability is conceptualized by this court, and a correspondingly heavy cost arises from applying unconscionability without careful reflection upon the rationale that underpins its existence. A leading statement of the unconscionability doctrine appears in Morrison and Coast Finance Limited, where Appeal Justice Davey remarked, quote, "A plea that a bargain is unconscionable invokes relief against an unfair advantage gained by an unconscientious use of power by a stronger party against a weaker. On such a claim, the material ingredients are proof of an inequality in the position of the parties arising out of the ignorance, need, or distress of the weaker, which left him in the power of the stronger, and proof of the substantial unfairness of the bargain obtained by the stronger. On proof of these circumstances, it creates a presumption of fraud, which the stronger must repel by proving the bargain was fair, just, and reasonable, or perhaps by showing that no advantage was taken." End quote. Appeal Justice Davies' statement of the principle reflects the traditional understanding that unconscionability requires both substantive unfairness, an improvident bargain, and procedural unfairness, an inequality of bargaining power stemming from a weakness or vulnerability affecting the claimant. While both of these elements are typically viewed as necessary, each does not have an equally important role. there is little support in the jurisprudence for the view that unconscionability operates solely or even primarily on the basis of substantive unfairness. To the contrary, the more settled view has been that the mere fact that a court sees a bargain as improvident or unreasonable does not make the transaction unconscionable. While this court has not closely examined unconscionability from a doctrinal standpoint, its references thereto support the view that unconscionability is intended to redress procedural deficiencies associated with contract formation, arising, for example, from abuse of an inequality of bargaining power or exploitation of a weaker party's vulnerability. The procedural focus of unconscionability has been similarly emphasized in the most recent appellate decisions giving thorough consideration to the doctrine. Although it is not necessary to decide it here, I note that some commentators have even argued that substantial improvidence in the resulting bargain should not itself be a requirement to establish unconscionability, as it simply serves as a hallmark of procedurally flawed transaction. This position was adopted in Downer, quote, jettisoning the requirement of a resulting improvident bargain as a requirement for the application of the unconscionability doctrine and affirming it, instead, as an important consideration in determining whether a position of inequality existed and whether it was unfairly taken advantage of, will bring the doctrine into line with the early English cases which placed emphasis on vulnerability resulting from a disparity of bargaining positions and the taking advantage of that vulnerability. End quote. All this leads unavoidably, in my respectful view, to the conclusion that unconscionability primarily addresses procedural concerns surrounding contract formation. In that sense, I agree with my colleagues. It also leads me to the conclusion, however, that a significant degree of procedural unfairness is required to invite unconscionability's application. While the procedural component of unconscionability is often stated as simply requiring an inequality of bargaining power, this phrasing is inadequate, if not misleading. Almost every contract involves some difference in bargaining power. Mere inequality, even substantial inequality, is therefore insufficient on its own to warrant application of unconscionability to set aside the transaction. Instead, unconscionability has traditionally been understood as requiring a particular vulnerability on the part of the plaintiff. As the Newfoundland and Labrador Court of Appeal concluded in Dower, quote, "It is not any inequality of position that will do. It must be such that it has the potential for seriously affecting the ability of the relief seeker to make a decision as to his or her own best interests, and thereby allows the other party an opportunity to take advantage of the claimant's personal or situational circumstances. This is why such terms as overwhelming or substantial or special have been used. I would venture to say that what is meant by such terminology is that the inequality must relate to a special and significant disadvantage that has the potential of overcoming the ability of the claimant to engage in autonomous, self-interested bargaining." End quote. Hence, the cases cited by my colleagues, which deal with elderly persons suffering from cognitive impairments, ship captains stranded at sea, and elderly persons with limited competency in written English and no understanding of the transaction they have agreed to. Each requires a degree of vulnerability particular to the claimant. By contrast, the only alleged procedural deficit in the agreement between Uber and Mr. Heller is the nature of Uber's contract terms, as they were presented to Mr. Heller through a standard form contract of adhesion. The argument is effectively that any party contracting with Uber would be in a position to raise unconscionability because they were unable to negotiate the contract's terms. While my colleagues readily accept this deficit as sufficient, this court has never before accepted that a standard form contract denotes the degree of inequality of bargaining power necessary to trigger the application of unconscionability. My colleagues see no reason to depart from the approach to unconscionability endorsed in Duez. And, indeed, they do not depart from Justice Sabella's separate concurring reasons in Duez, but they do depart from the majority's approach in the case. Specifically, in Duez, the court declined to address unconscionability in the context of a consumer contract of adhesion, and instead considered the matter through the lens of public policy. And the majority's view that standard form agreements are not inherently flawed is consistent with our liberal conception of freedom of contract, a value that accords great respect to individual autonomy. Though one may be required to accept a standard form agreement without negotiation to use a service, that fact affects neither party's ability to bargain effectively from the standpoint of legal autonomy, choice, and responsibility. Do as is, of course, a precedent of our court. The stakes are undoubtedly high here. Concluding that a standard form contract is sufficient to satisfy unconscionability's procedural requirement would open up the terms of every such contract for review on a measure of substantive reasonableness. This would represent a radical and undesirable change in the law, particularly considering the complexity and range of transactions to which unconscionability applies. The result of the inevitable, undisciplined application by courts of such an undisciplined expansion of the scope of unconscionability will be profound uncertainty about the enforceability of contracts. My colleagues further expand the scope of unconscionability by eliminating knowledge as a requirement. Unconscionability is generally viewed as requiring the stronger party to have at least constructive knowledge of the weaker party's vulnerability. A recent confirmation of this requirement appears in Downer, where the Newfoundland and Labrador Court of Appeal concluded that knowledge of either the claimant's vulnerability or of circumstances that pointed to special and significant disadvantage created or flowing from an inequality of bargaining relationship must be proven to make out the claim. Without accounting for or even acknowledging this controversy, my colleagues state that knowledge is not essential, despite a majority of scholars concluding that at least constructive knowledge is required. To reach this conclusion, my colleagues equate knowledge with wrongdoing. There is, however, a distinction between the two concepts in matters of unconscionability. While there is clear support for the proposition that unconscionability can be established without wrongdoing, that is, conduct rising to the level of intention, actual fraud, dishonesty, or active overreaching, the same cannot be said of knowledge. Even viewed as a plaintiff-sided doctrine, there can be no claim unless the defendant exploits the plaintiff's vulnerability. Accordingly, there is very little support for the direct application of strict liability in the context of unconscionability, which is what my colleagues would impose. There is a clear merit in a knowledge requirement, at least when applied to contractual dealings, as opposed to gratuitous transfers. Where the relationship between the plaintiff and defendant is contractual, equity's interest in protecting those who are vulnerable must be balanced against the countervailing interests of commercial certainty and transactional certainty. Equity therefore demands an explanation as to why the defendant should suffer the consequences of the plaintiff's vulnerability. Requiring knowledge on the part of the defendant makes it possible for both parties to know whether their agreement is enforceable at the time of contracting and provides a compelling reason for holding the stronger party accountable. The wholesale shift in the law that my colleagues advance by removing knowledge as a requirement, seemingly in response to the equities of this particular case, drastically expands the scope of unconscionability. It is neither supported by the jurisprudence nor counseled by academic commentary, and rightly so. Not only is eliminating the knowledge requirement a recipe for further uncertainty in the doctrine of unconscionability, it is commercially unworkable. Contracting parties are left to wonder whether an unknown state of vulnerability will someday open up their agreement to review on the grounds of fairness. This alone should give pause, but my colleagues do not stop there. Under their approach, a party who contracts exclusively with individuals who have received independent legal advice still cannot take comfort in the finality of their agreements. According to my colleagues, only competent legal advice will ameliorate an imbalance in bargaining power. A potential defendant therefore cannot be assured of finality unless it knows the content of the advice its counterparty has received. Moreover, this expansion of unconscionability is entirely unnecessary in the context of this appeal. Ultimately, the concern underlying my colleague's approach is simply that Mr. Heller cannot access any form of dispute resolution. As I have explained, this concern is already guarded against by a long-standing rule of public policy. And this court's decisions clearly demonstrate that where the concern with enforcing a contract relates primarily to the substance of a particular provision, unconscionability is not the appropriate doctrine for granting relief. This court has adopted specific rules to respond to public policy considerations, suggesting that the substance of a particular type of provision is cause for concern. For example, in Duez, the court declined to apply the doctrine of unconscionability to a forum selection clause appearing in a consumer contract of adhesion. Instead, inequality of bargaining power was raised as a relevant consideration in relation to public policy. In its reasons, the court provided specific guidance and directly addressed the mischief relating to a forum selection clause in the consumer context. The court has taken a similar approach to restrictive covenants that operate in restraint of trade, viewing those provisions through a lens of public policy. In both contexts, imbalance in bargaining power is a relevant consideration, but the degree of vulnerability necessary to establish unconscionability is not required. This reflects that the inquiry is grounded in public policy, addressing the substance of the provision at issue. By addressing substantive provisions of contracts through specific rules designed to address particular types of provisions, courts can provide, and have provided, concrete guidance addressing the relevant mischief. This court has approached the enforcement of contracts in a principled and rational manner by attempting to ascertain the existence and exact limits of the overriding public policy considerations that prohibit enforcement. The nature of the inquiry varies depending on the policy issues raised by the provision in question. Different considerations will apply in considering exclusion clauses, forum selection clauses, and clauses that limit access to legally determined dispute resolution. While these types of provisions might all be described as improvident in certain circumstances, it is critical to explain why that is so. Applying unconscionability in the manner suggested by my colleagues invites the conclusion that well-established rules relating to the enforcement of specific clauses should be swept aside in favor of a unified ad hoc and unprincipled approach to enforceability. This is why I say that, while unconscionability is appropriate for remedying procedural concerns that arise during contract formation, applying its generally framed requirements to address what are ultimately concerns of public policy will serve only to obfuscate the criteria for granting relief. In turn, commercial certainty is undermined. Indeed, the approach adopted by my colleagues embodies this concern by failing to provide concrete guidance for determining what substantive unfairness, or an improvident transaction, looks like. My colleagues assert that improvidence arises whenever a bargain unduly advantages the stronger party or unduly disadvantages the more vulnerable. Their approach is, they say, contextual and incapable of being framed precisely. My colleagues therefore invite judges to apply their own subjective, even idiosyncratic understandings of fairness and situational appropriateness in deciding whether a contract should be enforced. It is difficult to imagine a judicial approach more likely to undermine commercial certainty. Further, my colleagues say that terms may be unconscionable when a party does not understand or appreciate them. This suggests that Uber's agreement with Mr. Heller could have been remedied if the $14,500 fee for commencing a claim was spelled out expressly. As I have explained, however, even a contract that imposes express consequences for commencing a civil claim, like the contract in Nova Mese, will be contrary to public policy if those consequences rise to the level of undue hardship. It may be relevant to consider whether the stronger party obfuscated the limit on dispute resolution, but it cannot be determinative. Directly addressing the public policy concern at issue in this appeal, rather than obscuring it through the lens of unconscionability, allows for a more appropriate response to the problem. Finally, the doctrine of unconscionability was never meant to apply to individual provisions of a contract. Unlike public policy considerations that target a specific contractual provision, unconscionability's substantive inquiry must consider the entire bargain, that is, the entire exchange of value between the parties. Indeed, my colleagues seem to agree that a contract appearing to be unfair may be explained by showing that it is accounted for in the assumption of risk between the parties. And yet, nowhere in their analysis do they consider the overall exchange of value and assumption of risk between Mr. Heller and Uber, which may very well justify what appears to be substantial improvidence solely from Mr. Heller's perspective. While Mr. Heller was unable to negotiate the terms of his agreement with Uber, he did receive the benefit of working as an Uber driver and receiving income. The contract was in no way foisted upon him. In failing to even consider the value exchange between the parties, my colleagues ultimately create a doctrine of contract enforcement that rests entirely on grounds of distributive justice. I see no justification for this development and agree with Professor Benson, who writes, quote, "Unconscionability represents a conception of fairness in transactions or cumulative justice, not justice in distributions. It treats parties as equal by recognizing and protecting in each the power to receive something of equal value from the other in return for what he or she gives." End quote. Instead of examining the entire bargain, my colleagues assert that unconscionability can be alleged against specific provisions of a contract rather than the contract as a whole. In my view, however, this is a novel proposition. Some support for their position could possibly be drawn from this court's decision in Tircon, which requires courts to consider whether an exclusion clause was unconscionable at the time the contract was made. But nothing in Tircon or Hunter Engineering Company and Syncrude suggests an intention to adopt a novel approach to unconscionability that targets individual terms. In my view, use of the term unconscionability in Hunter Engineering and later in Tircon is explained by the fact that unconscionability is often used loosely to refer to a number of different concepts. In any event, the test set out in Tircon ultimately reflects a similar approach to that taken in Duez, which I find compelling. If a specific contractual term is properly incorporated into a valid agreement, considering the general doctrines of contract enforcement, then that provision should be held enforceable, absent compelling public policy reasons. In sum, my colleagues' approach drastically expands the scope of unconscionability, provides very little guidance for the doctrine's application, and does all this in the context of an appeal whose just disposition requires no such change. Here, there is no allegation that Mr. Heller suffered from any specific vulnerability that would traditionally ground a claim in unconscionability. It follows that there is no procedural deficit warranting the application of unconscionability to the agreement between Uber and Mr. Heller. The true concern is one of substance. Uber's arbitration agreement bars access to justice, undermining the rule of law. As I have explained, that concern is best addressed by considering whether the limitation on access to justice is reasonable in the circumstances, or, instead, imposes undue hardship. Part 3. Conclusion. The arbitration agreement between Mr. Heller and Uber effectively bars Mr. Heller from accessing a legally determined dispute resolution, thereby imposing undue hardship on Mr. Heller and undermining the rule of law. The arbitration agreement is unenforceable. I would dismiss the appeal with costs to Mr. Heller in this court and the courts below.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.